So the latter school of thought seems more appealing. So they are simply saying, don't go looking for the exact thing, go for what is similar, what looks like it. In other words, like it is even posited in this work, we can go for offenses that share fundamental common elements, such as murder and manslaughter, rape and defilement, stealing and housebreaking, etc. Then we look at the position in it. We have considered the common law position now, in as much as we try to juxtapose it to what is the practice in Nigeria. But let's look at the Evidence Act, which is the principal legislation on the law of evidence. Now, when you go through the length and breadth of Evidence Act, you will not see any place where the word similar fact evidence is mentioned or where register is mentioned. Rather, you're going to see provisions that tend to point towards similar fact, register. In other words, provisions that are similar to these doctrines, they exist under the Evidence Act. But then they have so much numerous exceptions that have so much water than the doctrine, instead that we can boldly say that this doctrine doesn't apply into Nigeria, or we can't find this doctrine in the Evidence Act as far as the common law doctrine is is involved in this. Then we also want to look at some basic provisions of the Evidence Act that create the impression of things that are similar to the doctrines we are talking about. These are basically the provisions that talks about relevance. And mind you that similar fact evidence is a common law doctrine that deals on relevance. Relevance. How relevant is it to adduce similar fact evidence in order to prove an offense that has been recently charged, an offense for which the defendant is standing trial? So I'm looking at provisions of sections 4 to 13 of the Evidence Act, and basically section 12, which says, when there is a question whether an act was accidental or intentional or done with a particular knowledge or intention, or to rebut any defense that may otherwise be open to the defendant, the fact that such act formed part of a series of similar occurrences in each of which the person doing the act was concerned is relevant. So when you look at this, you discover that a bulk of this provision is on the second exception. It's on the first and second exception to the general rule in marking against Attorney General of New South Wales. Right. But then, when it sought to introduce something that looks like similar fact evidence, it talks about similar occurrences. Similar occurrences. Similar occurrences here cannot by any stretch of imagination be interpreted to mean convictions. We'll come to that. And also, it watered it by saying, in each of which the person doing the act was concerned. In each of which he was concerned. It could be an act perpetrated by a lot of people, but this person might have acted as an accessory before the fact or an accessory after the fact. Would it then be convenient for us to apply the doctrine of similar fact evidence? The answer is no, with due respect. Now, one may likely be tempted to posit that the above provision is a direct recapitulation of the exception to general rule stated in marking against Attorney General of New South Wales, but that will not be correct. Even though the provision shares striking similarity with the exception, a cursory look at that provision will show two elements that are not obtainable in the common law exceptions, and they are: one, the act or offenses charged must have formed part of a series of similar occurrences. The act or the offense charged must be similar, must have formed part, not that it will be the offense charged in the past. So it will be a difficult thing to apply. Defendant must be concerned in each of the series. Now, the above provision is on its own, a general rule, and that provided to serve as an exception to any other rule, quite unlike the common law doctrine under discussion. So you can treat that as a different doctrine under Nigerian law of evidence, call it whatever, maybe doctrine of similar occurrences, but definitely it can be the doctrine of similar fact evidence. It's not. The said provision does not cover evidence tending to show that the accused has been guilty of criminal acts. We're talking about guilt of criminal acts in the past. So this provision has nothing to do with guilt. It has not linked the defendant with guilt. We're talking about occurrences, parts played, other than those covered by the indictment. Series of similar occurrences as contained in Section 12 of the Evidence Act has nothing to do with conviction of criminal acts. A setting of sections 4 to 12 of the Evidence Act will show that they have common elements that can be found in the doctrine, but no particular provision contains all the elements of the doctrine of similar fact evidence from sections 4 to 12 of the Evidence Act. They talk about relevance, cause, identification, same transaction, but none talks of similarity between the offense charge and the offense forming the previous conviction, nothing on conviction whatsoever. Now, Section 12 is considered to be a partial recapitulation of the exceptions stipulated in marking against Attorney General, but overshoots the bound, the provision, by making them relevant facts in proof of an act forming part of a series of similar occurrences, in each of which the person being charged has participated. This is obviously not a restatement of the doctrine of similar fact evidence and cannot be deemed to be so. For the common law doctrine of register, we are done with similar fact evidence now, but let's look at the other doctrine. Common law doctrine of register register is a Latin word, fully reading as register pare gestae. Register pare gestae. This simply means the thing done, or the thing is done. The thing done, or the thing is done. It is an exclusionary rule of English law of evidence, and is concerned with admissibility of statements made contemporaneously with the occurrence of some act or event into which the court is inquiring. For this, see the case of Akpan against the state, 1994, 8th Nigerian Weekly Law Report, part 3561 at page 226. Now, before going further, let me simply explain what the common law rule is saying, although I'm going to also talk about their conditions later. Is simply a rule of, an exclusionary rule of evidence, and is a rule that depicts or is taken as one of the exceptions to the hearsay rule, hearsay evidence. And it is a rule that gives room. Is it a cop from BCK? Tell him if he can come, he can come. Tell him to come. So if for instance now, just Z. If for instance an offense has been committed and there was no eyewitness as at the time that offense was committed, but somebody heard something. Remember that we said that direct evidence can be given by the person who heard and who saw. Somebody can hear but didn't see immediately as at the time it happened. Maybe somebody, you're walking towards somebody's house, and all of a sudden you hear a loud bang, and then maybe you heard a voice, "Oh, Mr. C has shot me," and then you rush, entered into the house to know what was wrong. By the time you got there, the person shot was already lying dead on the floor in his own pool of blood. But you heard something. You heard the noise of a shotgun, the sound of a gunshot, and you also heard a statement, Mr. C has shot me. And when you went in there, you discovered someone, is he coming? Was in a pool of blood. You discovered somebody was in a pool of blood. So circumstantially, it would be wrong to reject such evidence on the ground that is a hearsay evidence. That's why the Latin maxim re gestae pare gestae is applied to admit evidence of someone who heard, even though he didn't see, but both what he heard and what he didn't see happened contemporaneously at the same time. So it became an exception under common law that such evidence can be admitted, because it would be better that we admit that evidence to support even evidence of circumstantial evidence. But the only thing here is that it stands on its own. It is in its own class. Evidence of contemporaneity. That's what register is all about. So we need to know this so that when we look at the Evidence Act, we'll be able to decipher if we have such law operating in our rules. Okay. Now, in the American jurisprudence, res gesta is regarded as spontaneous explanations, just like I have said, is a spontaneous explanation. They can put on the agenda. It's a spontaneous explanation. And verbal acts which issues most of the times out of shock, excitement, or stress, which steals the reflective faculties and pushes them out of control. You know, somebody comes to your house and you are not expecting any danger, and all of a sudden he shoots at you. So that exclamation that one makes out of the situation of shock is taken to be something done in utmost good faith and in utmost truthfulness. Because the person being shot, the person, whatever he shouted at that time came from the bottom of his heart. There was no room for manipulation. There was no room for manipulation. He exclaimed. That exclamation explains at least a bit of what has happened. And the person who didn't see it happen but has heard it can lay evidence that I heard something like this, and when I moved in, look at what I saw. So that is how register operates. There must be that spontaneity, matching with the exclamation to show proof that something actually happened. The exclamation is viewed as a sincere response to the action that generated it. They are made impulsively. You don't even think. When you make such exclamation, you don't reason. It becomes a reflect. You don't even reflect over it. So it's not even a reflective thought. They are rather They rather reflect interest, disbelief, shock, involuntary reaction, and so on and so forth. For this, see the case of O'Leary against the king. O'Leary against, which is one of the important cases when it comes to register. O'Leary against the king, 1946, 13 CLR, page 566. The scope of the doctrine is not limited to statements, even though in Nigeria most of the decisions circle around statement, put on the phone. They circle around statements made, but they are not limited to statements made. But they also include acts or conduct. They include acts or conduct. The clarification of the Privy Council is instructive in this regard. Close the windows. Is instructive in this regard. For instance, in the case of writing against R, rapping, RATTEN, writing against R is reported 1972, appeal cases page 378 at page 388. In this case, register was categorized into two. The first one, proving of chain of events. Proving of chain of events. For this proposition, it referred to the case of Oliari against the king to show that the defendant killed the deceased as a result of continuous orgy of assault. Thus, the various acts explain the last act. Let me explain what I'm talking about here. In Oliari against the king, the defendant suffered series of assaults, and he decided to maybe retaliate, and retaliation resulted into something serious. He killed the defendant. And while maybe it could be that when he wanted to kill the defendant, he said, okay, I think this is, I want to bring an end to you insulting me, and then he shoots. Somebody passing by would have heard that sentence. There's a call. Somebody passing by would have heard that statement. I want to end your act of insulting me. And then there was just loud boom. And then the person rushes in. And it could be after he heard that. Now, let me also talk about the act now. He had an act, he had a statement, and then there was an act. So for the defendant, okay, now from the defendant, on the side of the defendant, the cumulative grievance over assault on his person culminated in the final act, which is the killing of the deceased. So his conduct, the act, if laid in evidence, amount to register. In other words, even if you extricate the statement, if nobody heard the statement, and it is possible to establish that he had grievances for which he killed this person, those grievances are acts, conducts, series of acts, series of conducts. They also amount to what? Register. You can hardly find any Nigerian authority on register that has been determined based on previous acts. All we can say are basically on statements that are contemporaneous because they are more easily applied and more easily understood than acts, previous chain of events. Now, the second categorization of register under our against writing is spoken words indicating directly or indirectly the identity of the attacker, which we have talked about, the spontaneous statement. Now, that spontaneous statement will explain what has happened. He has shot me. Who is he? Mr. Eze has shot me. It has told us the identity of the attacker, Mr. Eze.